question for the noble lord is why not?
My lords, my noble friend Earl Attlee indicated I should come along quietly. I'm not going to do that. I hope I will, however, come along realistically and clearly and set out the government's position, because there is no dispute in this committee that the behaviour which we're talking about is absolutely abominable and indefensible. I therefore appreciate, of course, why a new clause on this distressing subject of breastfeeding voyeurism has been tabled for debate. I want to start by expressing my unequivocal support to the mothers who've experienced that sort of appalling behaviour. We have heard, as the noble Lord Falconer just said, a number of, if I may say respectfully, really outstanding speeches, and some very personal speeches as to people's personal history and their families. I respectfully endorse, if I may, the points made by the noble lady Baroness Hayman and also by Baroness Brinton, that this isn't just a matter of protecting privacy or preventing distress. It's also important because we do want to promote the very real benefits of breastfeeding, and I take all the points made in that regard on board, and also the point made by the noble lady Baroness Jolly as to the bonding time, the quiet time, if I can put it that way, which it also provides. If I'm allowed as a minister in a UK government to dip into a foreign legal system for a moment, as to whether it also benefits fathers, because we don't have to get up at night, on that I will plead the Fifth Amendment. But I first of all would like to reassure the House, to pick up a point made by the noble lady Baroness Hayman, that it may be possible, and I underline may, because it won't be in all circumstances, I accept, but it may be possible, depending on the circumstances, that this sort of disgusting behaviour could be captured under some existing offences, including public order offences, offences dealing with harassment and stalking, along with the common law offence of outraging public decency. But I recognise that that is not a complete answer. I'm not putting it forward as a complete answer. We recognise that the law in this area is not always clear, and that consideration should be given to improving it. And that is why we asked the Law Commission to review the law around the taking, making and sharing of intimate images without consent, to identify whether there are, or really what are, the gaps in the scope of protection already offered to victims. And let me reassure the committee that the review specifically looks at the question of voyeurism offences and non-consensual photography in public places, including whether the recording and sharing of images of breastfeeding should be included in the scope of intimate images for the purposes of any reformed criminal law. But I do say that a change in the law here is not straightforward. With an amendment, and I'll explain why in a moment, such as the one put forward by the noble Baroness, there may be a variety of situations in which it may still not be an offence to take a picture of a person breastfeeding. And that's why the Law Commission's review is looking into questions of intent, the definition of image, and other circumstances relevant to this issue. As the committee is already aware, the Law Commission work has actually gone at some pace. They obviously have an important eye for detail. That's why they're there. They intend to publish their recommendations by spring next year. And so we are certainly not trying to kick this ball into the long grass. We are proactively considering what more can be done to tackle this behaviour and protect mothers now ahead of the Law Commission's recommendations for reform of the law in this area. But I do respectfully disagree respectfully with the noble Baroness that this is a clearly defined issue in the amendment. And I will pick up, if I may, at the point made by the noble Lord Panic, and we've had the benefit of some discussions, because there are a number of points which are, they look like drafting points, but they're not drafting points because they really go to the question, what is the scope of the proposed amendment? What is it seeking to encompass? And let me give a couple of examples without turning the Commission into a legislative drafting session. Let me give this example. A, and I'll try to use the initials from the amendment. A takes a photo of his wife or partner or girlfriend on a beach in her bikini, intending to use that image for his own sexual gratification. Another woman, B, is on the same beach, breastfeeding her baby, and is caught by A in the picture unintentionally. I do respectfully suggest, and I heard what the Noble Lord Panic said, but I do respectfully suggest that that would be caught by the proposed amendment. A would have no defence, as first he intended the picture for sexual gratification. He's recorded the image for that purpose. Second, he would have no defence of consent by B, first of all because B didn't consent, and A wouldn't also be able to have the second defence of reasonably believing that she was giving consent because he had no idea that she was in the picture at all. So that's one example. And this goes further than just drafting. Let's take a case where A is aware that B was caught in the background of the photo, but wasn't aware that she was breastfeeding. Again, wouldn't be able to say B was consenting, wouldn't reasonably believe that she was consenting. Further, would an image of someone breastfeeding, but which didn't actually include the act of breastfeeding, for example, a photograph only capturing a breastfeeding mother's face, be captured under this amendment? What parts of the body, if I can put it that way, would we require the image to capture? And as Noble Lady Baroness Brinton explained, this is different from the upskirting offence because that the law there does condescend to particular parts of the body which have to be captured in the photo. Would we wish to capture images taken of breastfeeding regardless of whether it is in a private, semi-private or public setting? Let me underline to the committee, I'm not raising these matters as points of drafting or to be difficult. On the contrary, we recognise the importance of this issue, but it's because this issue is so important that we have to get the nature and boundaries and scope of the offence absolutely correct.
Noble Lord, would he accept, however, in relation to his second potential problem, it would easily be dealt with by a drafting amendment to make clear that the offence relates to a photograph or video of a breast. It's not very difficult to draft that. In relation to his first concern, which as I understood it was that you, for the purpose of sexual gratification, you're taking a photo of your wife or girlfriend breastfeeding and there's some other woman in the background. I'm sorry, I've misunderstood?
Before he answers that question, and would he not also agree that we've got probably 7 or 8 weeks before we get to report stage, that these petty-fogging points that he's making could plainly be dealt with if we all sat around a table and agreed a draft?
If you're drafting legislation, the first thing we need to do is to make sure that we agree on the nature and scope of the amendment. I've tried to make it clear that I'm not putting these points forward as petty-fogging drafting. There are important points underlining this as to what we want the amendment actually to cover. And I don't know whether the Noble Lord Panic was about to rise again. Should I give him an opportunity to do so?
The Noble Lord's first example, it may be thought by members of the committee that the example that the Noble Lord gives is somewhat esoteric and unlikely to occur in practice. And the risk of such esoteric events occurring is more than outweighed by the actual mischief which this amendment is seeking to address. And in any event, the same points, the Noble Learned Lord calls them pettifogging, that's his word, but I understand why he says that, those objections could well be raised in relation to upskirting, that pictures could be taken, and in the background there's some other unfortunate woman whose photograph is taken. So perhaps the Noble Lord may wish to reconsider these matters, and we would all be very happy to sit round the table and agree a draft that meets these points. Yeah.
I've been in your lordship for nearly 30 years. I've seen plenty of examples where eventually the government's given way on an issue and parliamentary draftsmen have been able to draft far more complex provisions than these.
We are all united in our admiration for the parliamentary council and draftsmen. Absolutely, there's no doubt about that. But I don't know whether the Noble Lord Panic is a habitué of Instagram. If he were, he would appreciate that the example I've given is far from unlikely. People take photos of their wives or girlfriends, or indeed of people who they don't know, but who are not breastfeeding, for all sorts of purposes. And on the definition, on the amendment at the moment, if you are caught in, person B is caught in the background of the photo breastfeeding, there would be an offence. Now, that leads to the question, do we want to capture that? Do we want to capture that? Do we want to make that a criminal act? That is not a point of drafting, that's a point of principle. So the points I've been putting to the committee, of course I'm putting them by way of we need to draft this, but that's because there are points of underlying principle behind it. That is why we have a law commission, to help us in areas like this. I'm certainly not saying, in answer to the point made by the Noble Baroness Lady Brinton, that it is acceptable to delay for years. I'm saying rather that it's critical we get this right. If the Law Commission hadn't started their work or was going to report in 5 years' time, it would all be different. The Law Commission is reporting in this area in a matter of months, and I respectfully suggest that the appropriate way to proceed here is to see what they say, and then we can get an absolutely first-class piece of legislation in place. So I would invite, with respect, Noble Lady Baroness Hayman to withdraw the amendment.
My Lords, I'm extremely grateful to everyone who's spoken in the debate and for the support that has been shown from all sides of the House for taking action to combat a wrong that everyone accepts should not be allowed to be perpetrated. I, of course, listened with huge interest and respect to... I got a law degree, I don't want to be rude about lawyers, but to the, may I say, very legalistic response after the warm words and the acceptance in principle on the issue that the Noble Lord the Minister gave. He respectfully suggested to me that the best course was to wait for the Law Commission. He said for a few months. A few months maybe for the first round of the Law Commission, a lot more than a few months before we get the possible legislation. I respectfully suggest to him that there's another interpretation. We could legislate now, and when we have the Law Commission report on the wider issues, and we're looking at all the esoteric, I think was the perfect word, examples that he gave, that then we could put right anything that was wrong. But in the meantime, we would have taken action. In the meantime, on the 80-20 rule, we would have done a great deal to protect women. Not all women can breastfeed, not all women want to breastfeed, but those who do deserve the protection of the law. So I have to say, with respect to the Noble Lord, that I think perhaps meeting between now and report and trying to make this a better amendment in terms of drafting, and I take his point about what the purpose is. But actually, you know, I think the committee knows what the purpose is, and I think we could actually get an amendment that would do some good. But in the meantime, I beg leave to withdraw.
Your Lordship's prayer that this amendment be withdrawn.